from Vince and Association UK.
Good morning, Mr. Earley. Yes, my lords, my lady, I appear with Mr. Callas for the appellant in this appeal, Mr. Dale Vince. My learned friend Mr. White KC and Mr. Gallop appear for the Respondent Associated Newspapers. This is Mr. Vince's appeal against a decision of Mr. Justice Swift, striking out his data protection claim on grounds of abuse of process, and also deciding the alternative that the claim was amenable to reverse summary judgment. In terms of housekeeping, you should have a core bundle and supplemental bundle and a set of authorities. There are also 4 documents in front of you which should also have reached you electronically yesterday. The first of those is a replacement version of the chronology which needs to go into the bundle at tab 7. There was a small error spotted on the version that was originally there. Second is an authority referred to in my skeleton, Smith and Surridge. The third is the authority of SICRI, which we may need to look at in response to some submissions that Mr. White makes. And lastly is a colour version of the compare and contrast version of the EUWA. That replaces tab 28 in the authorities, but we weren't sure whether your hard copies had a colour-coded colour version or not. In the electronic version, that you can see the markup that shows the before and after amendments.
Yeah, thank you.
Subject to the court's approval, we're proposing that I should begin by addressing you on ground 2, that's a substantive ground about fair processing, and then Mr. Callas will address you on ground 1 after that, that's the abuse of process ground. I'm going to develop my submissions on ground 2 under 6 headings. First of all, a little bit about the factual background. Secondly, our pleaded case. Thirdly, our submissions on what we say the legal principles are governing the fairness of processing in data protection claims. Fourthly, our positive case on why we say that this is a case of unfair processing. Fifthly, Mr. Justice Swift's judgment on that point. And sixthly, why we say that judgment contained errors which this short court should overturn. So, beginning then with the factual background, as you know, this case concerns the processing of personal data through publication in a hard copy and online newspaper articles. Can I show you the hard copy first of all? This is in the supplemental bundle at tab 1, page 3. And you'll see that there's a prominent headline: Labour repays £100,000 to, quote, sex harassment donor. Beneath that, 2 photographs of Mr. Vince and a caption for those photos: roadblockers, Dale Vince in London yesterday, and circled as he holds up traffic with Just Stop Oil. And it's only when you read into the article that you realise that in fact that there are actually 2 stories here about 2 different Labour donors. One called a Mr. Serra, who it's reported has been found by an employment tribunal to have harassed a female employee on the basis of her sex, and the other Mr. Vince, a Labour donor who has gone on a Just Stop Oil demonstration. But one only notices that the story is about Mr. Serra primarily once one reads into the article. Anyone looking at the headline and the captions alone would think that it's Mr. Vince who is the sex harassment donor. Now, a facsimile of this hard copy article went to the press reader service. That's a site where newspapers are uploaded and can be viewed by subscribers, and it describes itself as the best place to read thousands of newspapers and magazines from around the globe. And this version of the hard copy article remained there until the 17th of October 2023. So that's about 4 months after it was first published in the edition of the Daily Mail for the 9th of June 2023. So that's the hard copy article. Can I show you next how the online article, the Mail Plus article, originally looked? You'll find that at tab 3 at page 7 in the supplemental bundle. I should say that this is a reconstruction of what this article would have looked like, because as it was edited in the course of the next few hours, it was overwritten. But the reconstruction has been helpfully prepared by Associated Newspapers, so you can take it that this is what the article would have looked like when it first went online. And it went online at about 10 p.m. on the 8th of June 2023. Here, a slightly different headline: Labour repays £100,000 to sex pest donor. And above that, one of the photographs, the one with Mr. Vince circled, and the same caption: road blockers, Dale Vince circled, he holds up traffic with Just Stop Oil in London yesterday. And again, the same confusion is created, we say. Anyone looking at that photo and that headline would assume that Mr. Vince was the sex pest donor, and they only realise as they read in to the article that in fact it's a story about two donors who've done two different things. At about 22:47, so 47 minutes after it's originally gone up, the online article has changed. The photograph and caption of Mr. Vince is removed and replaced by a photograph of Mr. Serra. I can't show you that, but it's common ground between the parties that that's what happened, and that's when the change occurred. And then finally, if you turn back to tab 2, you see a further change to the article. This happens at 10:18 a.m. on the 9th June 23. You can see not only has the photograph been replaced there, but the headline has been changed from sex pest donor to, quote, sex harassment donor. And we understand that came about because of a complaint by Mr. Serra, who thought that sex pest was an inaccurate or unfair way of summing up what the Employment Tribunal had found against him. So all in all, this is a pretty disastrous night on the subs desk paper. The online article, in its original form, manages to be unfair to both Mr. Vince and Mr. Serra. It requires 2 fixes in the course of the next 12 hours, and the hard copy doesn't get fixed at all. It goes out with a headline about sex harassment donor, immediately followed by those 2 photographs of Mr. Vince. And I should add that the combined readership of the Mail and Mail Plus at this time on weekdays was 2 million people. So that state of affairs was deeply concerning to Mr. Vince. See what he says about it in his original letter of claim. That starts at page 126 in the supplementary bundle, behind tab 9. It begins with a complaint of libel, but then on page 128 there is also a complaint under the UK GDPR. Various breaches of that regulation are set out there, including complaints that the processing was unfair. And under the section damage and distress, he says, or solicitors say, our client suffered and is likely to continue to suffer serious reputational harm as a result of the publication as set out above. He's also suffered considerable distress and anxiety as a result of the toxic imputation contained within the publication. He is understandably extremely worried that large swathes of the British public and beyond now consider him to be someone guilty of sexual harassment. So a complaint there not just about reputational harm, about distress and anxiety at the apprehension of what effect the article might be having. So those are the facts that have given rise to this claim. Can I then show you how the data protection claim is articulated in our pleading? For that, you need to look at the core bundle at tab 13, page 127. It starts with a recital of the facts as I've just taken you through. But the key passage then begins at paragraph 12 on page 129 in the bundle.
So this is the core bundle?
This is the core bundle, yes. Particular claims starting on 127.
I have a page 70, I have the particulars of claim.
Mr. Callis is just checking the electronic bundle, but we think it's page 127. The core bundle for particular claim.
You've got 127.
No, it's 127 of the core bundle.
Could you just send me the core bundle? Yeah, thanks. Okay. Which paragraph?
So I want to start at paragraph 12, which is where the processing complained of is identified and the personal data that it concerns. So in the penultimate line, the following acts by the defendant in relation to the claimant's name and photograph, being his personal data, were relevant acts of processing. Over the page, a publication in Daily Mail and on Mail Plus and Press Reader, and B, juxtaposing the claimant's name and photograph with a headline, Labour repays £100,000 to sex harassment donor. So that's the processing. It's his name and photograph being published in juxtaposition with the offending headlines. And the breach of duty, and it's the only breach of duty we complain of, is that the processing yes, my learned friend points out that Master of Rolls may be looking at the PTA core bundle. If you're still working with that, we'll try to give you the right page numbers as we go through.
Well, I'll get it. I think my lord's probably sent it to me now, so I've got the new one. Yeah, thank you.
Yes, so I was coming on to the breach of the regulation that we rely on, and it's a breach of the principle of fairness that is set out in Article 5.1a of the UK GDPR. And the reasons for the unfairness are set out in paragraph 15. What we say is that the process it complained of was unfair because it was unexpected and unduly detrimental without justification to the adverse impact. It created a misleading impression in the minds of those receiving the personal data. And then at paragraph 16, we give further pleading as to the claimant's reasonable expectations in this context. He reasonably expected the defendant wouldn't publish serious falsehoods or connect his name and photograph with serious allegations by juxtaposing the photographs and caption with the headlines of the article. I'm labouring that emphasis on expectations because the defendant seeks to present this case solely or centrally as a case concerned with misleading members of the public, which then sags into their argument that it should be treated in the same way as an accuracy complaint or a defamation claim. But for reasons that I'll develop, it's not centrally about misleading at all. It's centrally about the expectations of the claimant and how this processing falls outside what a person in his position ought reasonably to expect. I'll explain in due course why we do say that it's misleading, why that's part of our case, but it's categorically different, we say, from a claim that simply asserts that the data were inaccurate because misleading as to a matter of fact.
I mean, there's a difference, isn't there, between what is false and what is unfair?
Yes.
And
that's to say.
if it were just a question of false, then the defamation authorities, Charleston, would be in point, wouldn't they?
We're certainly not arguing otherwise in this appeal.
Right. So when you say in paragraph 16 of the particulars of claim that the claimant reasonably expected that the defendant would not publish serious falsehoods or juxtapose and would not use his personal data that would have an unjust adverse effect on him, some of it is sort of slightly missing the point of unfairness, isn't it? Some of that allegation.
Yes, I mean, the unfairness point is whether he should expect to see his data appearing mixed up with someone else's data at all, true or false. The reason it becomes...
But I mean, there's no embargo on mixing up people's data or drawing analogies or saying these people are both donors. I mean, you could have an article about donors to the Labour Party, which might have hundreds of people and hundreds of photos.
Yes, but dealing...
An open question whether that would be fair or not, but it might be.
Well, it might be if it dealt discreetly with each donor. What's unfair, we say in this case, is that he is muddled up with another donor.
But you've got to have a touchstone as to what's unfair. This is a very broad and important piece of legislation that applies to everybody and everything.
Mm-hmm.
And what I'm searching for is what you say the touchstone is of fairness. I mean, it's not just mixing up two articles and having two articles about two Labour donors which could, in theory, create confusion. That's not by itself what you say is unfair.
No, I am going to explain what the touchstone is. I'll do that under my third heading, the law,
Okay.
which I'm
I
about
mean,
to come
in
to.
a few words.
Let me tell you now in a few words. The requirement for fair processing has a three-part requirement. There are three issues to consider. The first is whether the processing concerned falls within what the data subject might reasonably expect in the circumstances. If it falls outside what the data subject might reasonably expect, then at the second stage one considers what the rights or interests of the controller or members of the public are engaged. And at the third stage, one asks, are the rights and interests of the controller and the public sufficiently strong to outweigh the expectations of the data subject, having regard to the harm that is risked or caused by the processing.
And where does all that come from?
I'm going to show you the law and the guidance that leads me to those propositions.
I mean, is there authority for that three-part test?
No, I derive it from the main Court of Appeal authority plus the Information Commissioner's guidance.
What, Johnson?
Yes.
Well, Johnson is a dissenting judgment of one judge after presumably not full argument on the point, right?
Well, we'll come to Johnson in a moment.
Okay.
That's...
Anyway, that's where you get it from.
Yeah. Can I...
Is that reflected in your pleading?
What we say in the pleading is a central concentration on the expectations of Mr. Vince. So we say it is sufficiently reflected in the pleading.
Without justification for the adverse impact. I
Yes,
suppose,
that's looking ahead to see
Yeah.
what might be
Yeah.
put against us.
You've covered what was said in the letter before action about damage. I haven't found any other evidence about damage. Have I missed something?
There's no other evidence at this stage about damage, and of course we weren't seeking summary judgment and damages at the same time. We were seeking summary judgment with damages to be assessed. But I did, before I move off the pleading, I did want to show you what is said about the damage. But before that, just paragraph 17, we explain that the unfairness that we complain of continued only in terms of the online article until the photograph of our client was removed. And of course that never happened in terms of the hard copy article, but we accept in the online article that unfairness in breach of Article 5.1a ceased at that point. That the article could still be criticised as unfair in layman's terms, but we say it falls outside the unfairness principle, but once his photograph is removed. And critically, that editorial change, taking the picture and caption out, makes no difference to the meaning of the article at all, or indeed its accuracy. But it's undeniably fairer to the claimant, we say. And that, we say, vividly demonstrates why questions of fair processing and the accuracy of personal data have to be considered separately. And then the damage pleading, paragraph 18, non-material damage is pleaded, including harm to reputation, so not limited to. You've already seen mention of distress and anxiety caused to Mr. Vince, which would fall under the concept of non-material damage. And then there's material harm, paragraph 19, because he's had to spend money approaching press reader and getting the article taken down at his own expense. And again, it's important to see the scope of damage claim, because the defendants seek to present this as a claim that is solely or centrally about damage to reputation, and we say it's not. That there will be actionable damage here, that even if we hadn't pleaded reputational harm, or indeed if the court were to consider in due course that reputational harm for some reason is not recoverable in this sort of case. Coming on to my third heading now, this is what we say.
Can I just understand paragraph 18? The non-material harm we know includes damage to reputation, but we're not told in paragraph 18 what else is covered by this.
We're not. That would be distress. That can be pleaded out if necessary. Yeah. People plead in different levels of detail. I think Mr. Callis is probably the more minimal end of a pleading, but it's there to be.
Brevity is a great virtue, but I just wanted to know what claimant's case is. It's anxiety and distress
as
and
described.
Reputational harm.
Yes. We turn to the law then and look first of all at Article 5 of the UK GDPR. Which you'll find in the authorities bundle at tab 26 at page 1032. This will be familiar. There are 6 different principles that are set out in Article 5.1a. The requirement to process fairly is part of the principle in 5.1a. The principle that personal data should be accurate, it is a separate principle in Article 5.1d. And Article 5.2 sets out the controller's duty to comply and demonstrate compliance with those principles.
So do you say this was inaccurate?
We're not pursuing an inaccuracy complaint, we're pursuing a fairness complaint. We accept that unless NT1 is wrong, we're not suggesting it is, that an accuracy complaint in this case would fail. But the point is, these are not coterminous duties. Processing can meet the objective standard of accuracy, but not the standard of fairness, we say, and that's this case. And just a little bit about the status of UK GDPR. It's a piece of what was called at the time of this processing directly effective retained EU law, but now assimilated EU law. And at the time of this processing, which was before the Retained EU Law Act took effect, the principle of supremacy still applied. Common law had to yield to provisions of the UK GDPR if they're in conflict. Fundamental rights under EU law were still part of domestic law, unless they were located only in the EU Charter. And the general principles of EU law were part of domestic law, including, of course, the principle of effectiveness. That's to say that the enforcement of an EU law right should not be rendered impossible or excessively difficult. And as is well known, interpreting EU law requires a purposive approach, and the purpose of the UK GDPR is evident, among other things, from the recitals. If you look back at the first recital on page 1000, it starts by proclaiming that the protection of natural persons in relation to processing of person data is a fundamental right, and then it cites two sources for that proposition. One is the Charter, which you must ignore. The other is Article 16 of the treaty, which is then summarised there. Everyone has the right to protection of personal data concerning him or her. But then at recital 4, we see that that fundamental right must be kept in balance with other competing rights, including the rights of controllers of the public, and they all must be kept in balance by reference to the principle of proportionality. Now, coming to case law on the fairness principle, the key authority is Johnson, the Medical Defence Union, which is at tab 16. In the authorities bundle, page 518. This was a claim by a surgeon against a decision by the Medical Defence Union to refuse to renew his insurance cover. The Memorandum and Articles of Association of the Union, so in other words a contract between himself and the Union, that gave the Union wide powers to refuse to continue insurance, and the Union exercised those powers in Mr. Johnson's case following a risk assessment. And during that risk assessment, the MDU looked at a number of complaints against Mr. Johnson, but didn't contact Mr. Johnson for any further information about those cases. Now the majority, that's Lord Justice Buxton and Lord Justice Longmore, considered that this was not a claim about unfair processing at all. The unfairness, they said, lay in the decision-making of the human risk manager, but not in any processing. It was only the minority judge, Lady Justice Arden, who considered that it was a claim about processing of personal data, and it's she who addresses in detail what the fairness principle requires. But majority judgments did go on to consider the fairness of processing in the alternative, and neither disagreed with the approach that Lady Justice Arden took to that topic. This was a case under the Data Protection Act 1998 and the directive which it implemented. The 98 Act is structured slightly differently on this point from UK GDPR, but there are no differences of any great principle. The Lady Justice begins her consideration of the fairness principle at paragraph 137, page 568 in the bundle. And you see from paragraph 140 that the particular issue of concern in Johnson was how the fairness principle interacts with the parties' contractual agreement that I've described. Did it require the MDU to revert to Mr. Johnson and consult, but notwithstanding the absolute discretion that the union had under the contract? So not the same context as our case, we accept, but we say the observations of Lady Justice Arden on fairness are of wider value here. Paragraph 141, she says, the very word fairness suggests a balancing of interests, but in this case the interests to be taken into account would be those of the data subject and the data user, and perhaps in an appropriate case any other data subject affected by the operation in question. At paragraph 143, she acknowledges that if a person is deceived into handing over data or misled as to the controller's purpose, that then there may be unfairness in the resulting processing. But then she goes on to say there can also be principal unfairness where a person freely agrees to hand over the data. So a contractual situation, for example. And at paragraph 143, she introduces the concept of foreseeability as a way of judging fairness. She says by little b that this fact is likely to be a critical one where the parties freely entered into the contract. The data user intended to do no more by way of processing the information than he was entitled to do with it manually under the terms of the contract, and the data subject should reasonably have foreseen the data user might wish to process the information for this purpose. And she returns to the idea of foreseeability again at paragraph 149, where she says, for reasons explained above, as a general proposition, a party to a contract cannot, in my judgment, use the fairness principle as a means of upsetting any contractually permitted use of information where, as here, processing was foreseeable. We say that foreseeability or reasonable expectation is a touchstone generally for the fairness principle. It's that consideration that explains why, for example, it would be unfair if data are obtained by deception or there's a lack of clarity about the controller's purpose. And we say it applies here, that where a data subject like Mr. Vince has put their personal data into the public domain so that it's accessible and reportable by the press. But the question is, what processing can he reasonably expect of those data in those circumstances?
It's a very different situation, this.
Of course it's a different situation, but I'm now going to show
I
you
mean,
guys...
it's very dangerous, isn't it, to take as a sort of final exposition of the meaning of a very, very wide-ranging statute, something that is so contextual. I mean, she was thinking of professional liability, of foreseeability, of all sorts of things that are quite different here. I mean, surely one has to step back from one case that, you know, is slightly unsatisfactory because it's so contextual, and consider the meaning of these words in the context of the legislation. And I mean, are there no authorities elsewhere in Europe that are relevant? Has there ever been a case where damages have been awarded for a breach of the fairness principle?
Not based on our researches, no.
No, not ever.
Not that we're aware of.
Right. So, I mean, if it's that groundbreaking, surely we need to give some fairly high-level consideration to what this was supposed to mean.
Well, where you can be helped then is where I'm coming on to now, which is the Information Commissioner's guidance. Commissioner, of course, an important regulator regulator in this field, has to survey the whole field of data protection and apply these principles, and has enforcement powers as well. If there's an alleged breach of the fairness principle, the Commissioner has to investigate and apply his interpretation of the law to those facts. And so we say that the Information Commissioner's guidance on this is of value, and there are...
When was it published?
The first guidance I'm going to show you was published in 2014, second guidance was 2024.
Can you just remind us of the status of this under
The first
it's
guidance...
admissible guidance, isn't it?
The first guidance I'm going to show you is a piece of non-statutory guidance that the Commissioner decided himself to issue back in 2014 to the media. The second piece of guidance is statutory guidance, which came into force in February 2024, so after the processing we're looking at here. After that date, the court has a duty to have regard to that guidance. What we say is that all the second set of guidance does is elaborate to some extent on what is said in the first set of guidance, not suggesting there's been any change in the law. And we say that you can be helped by looking at both sets of guidance when grasping for what fairness means in the context of publication in the media.
Are we going to be looking at the editor's code as well?
We will briefly mention the editor's code. Different with the editor's code is it doesn't have a fairness requirement. It addresses fairness in a slightly different way. But the principal guidance, we say, is the ICO guidance here. Can we look at the 2014 guidance first, which is tab 30 in the authorities. The relevant part starts on page 1145. This is an explanation of the principle of fairness as it applies to the media. And about halfway down the page, but having set out the principle, the Commissioner says this generally means that the media need to be open and honest, tell people they're dealing with and the data subject is different, who they are and what they're doing, unless that's not practical, not cause people any unjustified harm, and not do anything that they wouldn't reasonably expect. So there we see this question, this concept of reasonable expectation balanced against the question of unjustified harm being landed upon by the Commissioner as a way of explaining what fairness means in the media context. That is then expanded on in the current statutory guidance, which starts on page 1159. If you just look at the contents page first of all, page 116.
Sorry, 1159
Yeah.
is 2024, isn't it?
That's the 2024 version, yeah. If you just look briefly at the contents page on 1160, that you see the structure of this guidance. It goes through all of the principles and then comes to the journalism exemption later on. And then you see what it says about the fairness principle at 1175. And here it's even more explicit. Paragraph 5.2. How do we comply? To use personal information fairly, you should use it in ways people reasonably expect, or you should be able to justify any unexpected use. And then also of relevance, because this is where I get the third limb of my proposition about how to approach fairness, is 5.7, unwarranted harm. You should act proportionately, taking into account the public interest in using the personal information and any harm to the person concerned. You should be able to justify any harm in view of the person's reasonable expectations. So, for want of any direct authority on the point, that is where I derive the test that I put forward to you today. And the starting point, of course, is the expectations of the data subject. And that is in contrast with the approach under the accuracy principle in Article 5.1d, because when the question is whether data are accurate, the focus is necessarily on the meaning that they convey to the person to whom they are disclosed.
This kind of proportionality approach requires a weighing up of the harm.
Yes.
On the one side, and then the justifications, whatever they are, on the other. And as you pointed out, we don't know what the harm is because it's not been put in evidence.
But no, the harm is that it's misleading, that the members of the public will be misled, and that's pleaded. And in a mass publication case like this, you can assume that there will have been readers out there who just saw the headline and the captions. And indeed that everyone was briefly misled as they read through the article. Some will have remained misled because they never read on. Others will have had their misunderstandings corrected. But that's the harm that needs to be weighed, we say, against whatever journalistic interests the defendant can put forward.
I mean, the problem with making it what the data subject would reasonably expect is that it may have all sorts of unexpected outcomes.
Well, it's not about expecting the outcome, it's about expecting the processing.
Yes. No, I mean, what people may reasonably expect may or may not be compatible with what journalists think is appropriate. So people might not reasonably expect a Labour donor to have a newspaper link the Labour donorship with the Just Stop Oil activity. Might not reasonably expect that, but journalists, it's the kind of thing journalists might like to do. So it creates. I mean, I entirely understand where you get it from. I just think it's a rather strange way of assessing fairness. Because fairness, as Lady Justice Arden pointed out, is a balance.
Yes.
So if you're looking at it entirely from the data subject's point of view, that's not really the balance that fairness requires.
Yes, but I'm not, because stage one, you look at the data subject's expectations. Stage two, you put into the balance whatever the journalist says is the journalistic reason for processing the data in this unexpected way. Stage three, check the proportionality of that balance.
So in your approach, if the use made or the processing undertaken is within the scope of the reasonable expectation, you stop there.
Yes.
That's the end of the analysis.
Let me get on to my
Yeah.
positive case on the facts, because I think it will become clear at that point. So this is my fourth heading. Our positive case is why we say.
Can I just ask you about the code?
Yeah.
Because I think it was part of your case that the Human Rights Act requires the court to take into account any relevant privacy code, and the ipso editor's code is such a code. And for my part, I just wanted to test this with probably both of you. Although paragraph 1 of the code comes under the heading of inaccuracy, it seems to talk about misleading in a way that's hard to reconcile with Charleston. So it says, among other things, that newspapers, I'm I'm not reading it, but shouldn't publish inaccurate or misleading data, including headlines that aren't supported by the text.
Yes.
If Charleston applies, headlines that aren't supported by the text are not misleading. They're perfectly fine because you read the whole thing. So this seems to presuppose that you can be, in terms of the code, inaccurate or misleading. If you say, if this had been a case where the headline had been Dale Vince is a sex pest, and then you read the article and find it's all about someone else. So that would have been misleading under paragraph 1, arguably. Does it make a difference if what is said is there's a sex pest out there who's a Labour donor and here's Dale Vince, and then the article says something different? Just struck me that that's one way that it might be analysed.
Well, let's answer your question on the code. The code is a bit of a fudge. The reference to headlines having to be supported by the text was brought in by amendment. I think the first time that there'd been any sort of public consultation on the code.
No, it's the first time that there have been lay members on the code committee.
First time there'd been lay members on the code committee. The committee couldn't bring itself to bring into effect a separate requirement of fairness, but what it's done by putting in that requirement that a headline should be supported by the text is a gesture towards fairness. As we say, that's about as far as it goes. Your Lordship's right, it doesn't sit with accuracy or misleading in the Charleston sense at all. It's a departure from Charleston, and it's their attempt to try and bring some fairness into the scheme, I think.
Thank you.
So, just to bring these submissions back to the facts of this case, we say it is a straightforward case that is amenable to summary judgment in our favour now, and it proceeds as follows. Mr. Vince is a man with a high public profile. He makes no secret of the fact that he's given money to the Labour Party, makes no secret of the fact he's got strong views on environmental issues, or that he had joined that public Just Stop Oil protest and been photographed. So a reasonable person with those characteristics and in his position must expect such matters to be publicised in the press, even subjected to strong criticism. Allegations of inconsistency, hypocrisy, disloyalty, undue influence, etc. They might all be unfair in layman's terms, but they're all within the scope of what a person in Mr. Vince's situation should reasonably expect. And the fairness principle is not going to be engaged in those situations. But while a reasonable person in Mr. Vince's position can expect publicity or even criticism for the things he does do, no one in his position reasonably expects to be confused with someone else who's done something altogether different. So at stage 1 in the 3-stage inquiry that I've postulated, we have processing that no person in Mr. Vince's situation could reasonably have expected, the juxtaposition of his name and image with a headline about someone completely different. Then at stage 2, you ask what the objective justification for that may be. And the answer we discern from Associated's position is that they wanted to tell 2 stories in the same article. You may have seen the account of the night editor, Mr. Gregory, in the supplementary bundle. That appears to be what he's saying. We had 2 stories to run, we had limited space, we decided to run them together. I'm not going to take you through that bit of his evidence, but it's paragraphs 5 to 12 of his witness statement, which begins at page 228 in the supplemental bundle. And at stage 3, you ask, is that objective justification strong enough given the risk of harm arising from that unexpected processing? And the harm we've identified in this case is that readers, or some of them, may be misled into thinking something about Mr. Vince that's false. Pausing there, That won't always be the relevant harm in an unfair processing case concerning legal publication. Imagine, for example, that contrary to my reasonable expectations, a newspaper identifies me correctly as someone who's won the lottery or who's a secret benefactor of a large charity. In a case like that, the harm would be at the risk of unwanted attention from gold diggers, unwanted publicity, etc. And the question would be, was there a sufficiently strong journalistic reason for making that disclosure, even though it was beyond what I reasonably expected, and given the extent of the risk to which it exposed me? So not all unfair processing cases are going to be about the public being misled. But in this case, we have identified that the relevant harm to consist in readers being misled. But nevertheless, that question, arising as it does at stage 3 of our analysis, is distinctly different from the issue that would arise if Mr. Vince had brought a complaint under the inaccuracy principle. In that scenario, there would be a binary question. Is the publication misleading or not? And it would be very hard to resist the proposition that as a matter of law, that binary question has to be considered looking at the data in the context of the article as a whole.
Sorry, just say that again.
If the binary question is, are these data accurate or not, it would be hard to resist the proposition that that question has to be answered by looking at the data as they appear in the context of the article as a whole.
But that's the problem, isn't it? It's how the interaction between accuracy and fairness is to be judged. It's quite a difficult problem because you keep on talking about misleading, and misleading is actually about inaccuracy. There wouldn't be any misleading if the way it had been put was accurate.
Yeah.
And so and that's what gives us the difficulty about Charleston, because I mean Charleston and defamation, I think, are not rights that derive from Article 8, but misuse of private information and data protection does derive effectively from Article 8. We see that in the recitals, and we know it from Google and Lloyd and Google. And it's strange that you have a no defamation right based on inaccuracy, which is the basis of that tort. But when you come to Article 8, inaccuracy is relevant but not determinative. And of course, your primary case is that what was said was inaccurate. It gave a misleading impression. You wouldn't mind.
No, that's not my case. My case is that the processing confounded my client's reasonable expectations without sufficient justification, the harm of which was that the public were misled.
I get that's the way you formulate it, but the substance of what you're complaining about, I understand the formal legal submission you've made to us, but what you're actually complaining about is they juxtaposed a picture which gave a misleading impression to many members of the public, and it's a perfectly fair complaint, if I may say so. But the question is how that plays into the legal foundation for the claim you're making, because we have to consider, and I personally think this is a very important part of this case, what the ramifications of finding you're right are in other areas, because it's not just this case that matters. There will be many other situations where inaccurate things have been said in part of journalistic articles, and indeed in many other places.
I will be addressing you on the floodgates issue.
But it's not floodgates, it's consequences. My reason for saying that whether
the article is misleading or not is a binary question in an accuracy complaint, but not necessarily a binary question when it crops up at stage 3 in a fairness complaint is this, because at that stage you're conducting a balancing. That test admits of nuance and fact and degree, because the court is trying to assess whether there's a sufficiently strong justification for processing data in a way that the data subject didn't reasonably expect. And so at that stage, it's perfectly logical for the court to find that some but not all readers will have been misled, or that some have been misled only momentarily and some more permanently, because all those considerations go into the balancing exercise at that stage.
So can I ask this? If what had happened was genuinely a mistake, right, so nobody intended to say anything untoward about Mr. Vince, but there was genuinely a mistake in combining the two articles. It may be this case, I'm sure that's what Mr. White would say, but it doesn't matter. It is genuinely a mistake and it's corrected immediately. But it is obviously, by your three things, whether or not by reference to your three things, it's jolly unfair and has had terrible consequences for the data subject. That does, the proportionality balance must mean that it's unfair, must it?
No, because one of the things you would look at is the duration for which the unfairness persisted and how many people might have been misled during that time. You could take that into account.
Well, if it's a big publication, maybe lots.
Yeah, but we say it is lots here. And
So it doesn't matter whether it's genuine or not, whether it's a genuine mistake or not, really.
no, it doesn't. We're certainly not running a case. This was somehow malicious processing.
See, I thought you said that the second test, we'll go back to it, but I thought you said the second test, the rights or interests of the controller or members of the public are engaged, and that means that the rights and interests of the controller are having to run a newspaper in a busy newsroom and wanting to obviously get the copy out.
Yes. That's what they say in this case. We had two stories and only a certain amount of space to put them.
But I mean, the question of whether it's a genuine mistake is quite a difficult one, isn't it? Because obviously if they'd intended to do it and didn't care, publish and be damned, that's one thing. But if in terms of fairness, it would be much more likely to be unfair if they'd taken that approach than if they'd said, we made a genuine mistake and corrected it as quickly as we could.
Well, we don't need to go that far in our case. We would suggest that fairness is a purely objective test. If there is some subjective animosity or recklessness, well, maybe that's a case for aggravated damages, but it doesn't go to liability.
The objective purpose of what they were about would be relevant.
Yes, we're a newspaper.
They're running a story about neighbour donors and their behaviour.
Yeah.
That would be a relevant factor, whatever they thought about it.
Yes. I think you've got the flavour of how we put the case now. The last thing to mention on this case is we say there's no prospect of the journalism exemption coming to the rescue of the defendants here. But perhaps it's best if I just move on now to what Mr. Justice Swift says in his judgment about how he's approached this issue, and then to expand upon why we say that's wrong. So this is my fifth heading, the judgment.
I'm not going to say any more about the possibility of a journalistic exemption.
I can explain that now if you like. Why don't we do that now? So if you want to turn up the exemption, it's page 1073 in the bundle.
I mean, it seems to me that the journalistic exemption, the existence of a journalistic exemption may be relevant to the appropriate test, whether or not it's applicable.
Yes, certainly, because it means it's not, even if on an objective test, that there has been processing in contradiction of the claimant's reasonable expectations, and there's no objective justification for it, given the harm it's given rise to, but there's still a journalism exemption that the journalist can go to in an appropriate case. So it's a very important part of the mechanism of balancing freedom of expression rights against data subject rights. So if you just look at the wording exemption at 1073, it effectively has three requirements. First of all, in paragraph 26(2)(a), processing being carried out with a view to the publication by a person of journalistic, etc. material. That's certainly satisfied here. Second, controller reasonably believes that publication of the material would be in the public interest. Again, assume that the defendant can overcome that hurdle here. But then, critically, the GDPR provisions don't apply to the extent the controller reasonably believes that the application of those provisions would be incompatible with special purposes. So what the defendant has to show at stage 3 is that a relevant editorial person has recognised that putting a picture of Mr. Vince beneath the headline about a sex pest did amount to unfair processing, but nevertheless considered that it would be incompatible with their journalistic purposes to choose a headline and pictures that avoided that unfairness. And moreover, the defendant has to prove that that is a reasonable belief to have held. Now, Mr. Gregory doesn't give that required subjective evidence of that thought process, but even if an editor did in this case, how could that be that the processing Mr. Vince's data fairly was incompatible with journalistic purposes be a reasonable view, when, as we know, within 47 minutes of this article going up, they've managed to meet their journalistic objectives without any unfairness at all, because the unfairness disappears as soon as Mr. Vince's photo disappears. So that's why you can be confident even at this stage that the journalist exemption will not assist the defendant in this case on its very unusual facts. So that's our positive case. You have processing Mr. Vince's data in a way he didn't reasonably expect. You have limited justification for that, which is not strong enough to justify the damaging effects of the publication. And you have a lack of any prospect of the journalism exemption coming to the defendant's assistance. And you also have damage in terms of material damage and non-material damage, both of which are recoverable under Article 82. Whether damage to reputation is recoverable in this situation is something that can be determined in due course. But for present purposes, you can be sure there is at least some actionable harm. We now go to the judgment, please. It starts at page 98, tab 9 in the core bundle, and we'll just check where it is in the commission bundle.
If you just give us paragraph numbers, I'm sure we've...
Yes, of course. It's the discussion of fairness starts at paragraph 30, and conclusions and reasoning really comes paragraph 37 onwards. Thanks. Paragraph 37, he says, to state the obvious, fairness must depend on context. And in the context of UK GDPR, fairness must also be assessed objectively, reflecting a balance of the interests of the process of the data subject to the public interest. We accept that, that's entirely right. That's what we say you get from Johnson MBU. And the context here, we say, is you've got Mr. Vince, who's a high-profile individual, who's put a certain amount of data into the public domain. It's been published and processed by sending it to the world at large, and that's the context against which his expectations had to be judged, and the justification of processing it in that manner has to be assessed. But then at paragraph 38, there are three features of the judgment which we say are incorrect. First of all, in paragraph 38, the judge characterises the claim as our case being that it's unfair because the headline and the pictures gave a misleading impression, and that his reputation has been damaged. And further down, about 4 lines up from the bottom of the page, he rather doubles down on that and says the primary harm caused is said to be reputational damage. So that's one element of this paragraph that we disagree with, and I'll explain why in a moment. The next critical part of the paragraph that we say is wrong is that he says that he considers it's correct to determine whether personal data was processed fairly, taking an approach that, like the rule in Charleston, takes account of the entirety of the publication. And then he goes on to say that as is apparent from Lord Nichols' speech in Charleston, the rule represents a balance struck in the public interest between competing considerations. That's the second controversial proposition in this paragraph. And the third comes near the bottom, just above the reference to Sitri, where he says the law will be incoherent if the fairness of the processing was assessed other than by considering the entirety of what was published. So let me expand on why we say those three elements of this paragraph are wrong. The first error is to frame our complaint about misleading information that has caused reputational damage. But those elements are present, of course, as part of our case. But fundamentally, our case is that the newspaper has processed Mr. Vince's personal data in a way that was contrary to his reasonable expectations. You've understood my position on this already. We do say that the combination of his personal data with the headline is apt to mislead certain readers, and that's the harm the court has to have in mind, but when considering whether the defendant had any sufficient justification for processing the data in that way. But that is different, we say, from saying that the claim is a claim for the processing of misleading personal data. That would be straightforwardly a claim under the accuracy principle, 5.1d, and where the binary question is, does this or does this not mislead? That would be the very gist of a claim under the accuracy principle. That's not the claim we make. Likewise, it's wrong to say this claim is solely or principally about reputational harm. So framing this claim as the judge does, as a claim for reputational damage arising from the publication of misleading information, we say sets him off on the wrong foot. He's looking at it from the wrong perspective. The second and bigger error is to reach out to Charleston in these circumstances. We say that's inapt, and it's not an authority that gives any clue about the general balancing of public interests or free expression rights, or says anything that can be transposed into a fairness assessment. In our skeleton at 43, I acknowledged that I Lord Justice Warby has taken elements of the libel rule in NT1 and in the Arvin case and used that as a tool in the data protection context in NT1 to assess accuracy, in Arvin to identify what the personal data were in the first place. I'm not saying that those decisions were wrongly decided. That's not part of our case in this appeal. But it was an unusual approach because the court was engaged in interpreting and applying the words from EU legislation, which of course has an autonomous interpretation. In my skeleton, I explained 3 reasons why it was an acceptable approach in NT1 and Arvin. First of all, there was a gap to be filled because there was nothing in data protection law itself that said anything about those matters. Secondly, there was a cognate principle in the common law you could conveniently reach out to and which read across in a way that fitted. And thirdly, adopting that approach didn't conflict with the purposes of data protection law or any case law or guidance. But those features aren't present in this case, and it's not justifiable, we say, to reach out to the Charleston principle or something like it. Because first of all, there is already law and guidance on how to determine fairness in the data protection case. That's the Johnson case and the ICO guidance I've shown you. Second, neither Charleston specifically nor libel law in general provides any assistance on the question of fairness. It'll take me a little while to develop this submission, but we start by saying that the judge here greatly overstates the significance of the Charleston decision. It's not a case that is saying anything about balancing of public interests generally in the law of freedom of expression. It's a case that's very narrow in its scope. We look at Charleston, please, which is at tab 15 in the authorities, page 508. The facts are very well known, of course. Article with headlines and photos that, if you read them in isolation, meant that the claimant had participated in or approved the production of a pornographic video game that featured their images. But then when you read the article as a whole, it's made clear that they were in fact the victims of unscrupulous games producers who had taken their images without consent. And the claimant's argument on appeal was that it was legitimate to complain about the publication to the subset of readers who had only read the first part of the article and seen the pictures, and who would have understood it in that defamatory sense. If you look first at the speech of Lord Bridge, page 69, he stresses at E to F the narrowness of the question before the court. He says he's not pronouncing on questions of journalistic ethics or whether the publication of photographs by itself constitutes a novel tort. The single question of law to which the appeal gives rise is whether the plaintiff has any remedy in the tort of defamation on the basis of their pleaded claims. And this in turn narrows down to the question whether a claim of defamation in respect of the publication which it is conceived is not defamatory considered as a whole may nevertheless succeed on the ground that some readers will have read part only of the published matter. And then over the page at page 71, between F and H, he identifies 2 basic principles of libel law, which he describes as follows. First of all, that meaning in defamation is determined by reference to the impression made on a reasonable reader. And secondly, that there is only one meaning. And he doesn't offer any reasoned defence of those principles. He simply says they're as old as the hills, and then he refers to what Lord Ditlock said about them in Slim, which he sets out. I won't read it through, but essentially Lord Ditlock says that this rule has come about because that's simply how lawyers think. They look at documents, they look at contracts, they look at statutes, and they seek to work out what the one thing that is being said by whatever document they're looking at. And then at page 73, little b, he explains that once you take those two principles, that the single meaning to be judged by the standards of the reasonable reader, he says the claimant's claim can't succeed in this case because essentially it is a feature of the reasonable reader that they read everything through and don't just stop at the headlines. He says that just above little c, that such a reader could hardly be described as ordinary, reasonable, fair-minded readers.
Sorry, where's that?
Just right at the end of the speech, between B and C. And then we have Lord Nicholl's speech, which is one that Justice Swift specifically refers to. Page 73, between G and H, he notes that the common law hasn't taken the common sense approach of recognising that different readers read differently, but has, quote, long ago gone in a different direction and adopted what he calls a single standard, by which he's referring to the same thing that Lord Bridge has said, a single meaning judged by the standard of the reasonable reader. And he doesn't venture into any defence of those rules either. He says it's a crude yardstick by H. The only justification he gives is over at 74. He says, it is indeed in this very consideration that the law finds justification for its single standard. In other words, unless we have the single standards, that way chaos lies, because there is such a plurality of readings of any particular article. And then at B on page 74, he simply says, like Lord Bridge said, that you cannot reconcile that approach, which is etched in stone, with an approach where some readers are considered not to have read the whole article. So there's nothing in Charleston to suggest that the House of Lords was there determining the matter from first principles, or thinking about or trying to strike the correct balance between public interests and private interests in the journalism case, not even in respect to meaning, let alone more generally. But then if we look at some later treatments of the single meaning rule, look on to tab 17, the Aginomoto case. Starts at page 573. This was the case where it was open to the Court of Appeal not to apply the single meaning rule in the tort of malicious falsehood, and they declined to do so, and they made some scathing criticisms of the rule as they rejected it. So we have Lord Justice Sedley on page 584, paragraph 31. Rule itself is anomalous, frequent OTAs and where not OTAs unjust. The anomaly is very nearly common ground. With the help of council scholarship, we've seen how a pragmatic practice became elevated into a rule of law and has remained in place without any enduring rationale.
So which paragraph did you say that was?
31 and 32, so I've just read into 32. So recognising what's already clear from Charleston, it's not a profound freedom of speech case, it's a recognition of a pragmatic approach that helps in libel cases. And then he says over the page at 585, by little a, the reason for not following that rule in malicious falsehood is because it makes the trial of the issues fairer and more realistic. And then we have Lord Justice Reimer at paragraph 43. I've set this out of my skeleton as well. I won't read it out now, but essentially the point he makes there is that if the Charleston rule does achieve any fairness, that's complete happenstance. Similarly, the court has, at least at first instance, has declined to follow the single meaning rule in privacy. In the case of Smith and Surridge, that's one of the additional authorities that we handed up. This was a claim for libel, negligent misstatement and misuse of private information based on an employment reference for teachers. What the employment reference said, you see this paragraph 2 in the judgment, is that there were some safeguarding issues during their time at Stanborough School. The judge determined the natural and ordinary meaning of that for the purpose of the libel action and said it meant that the claimant, during the time she worked at the school, did something that gave rise to a safeguarding issue, namely something that either caused harm to a child or placed a child at risk of harm. The claimants then took that meaning and tried to rely on it to get a privacy case off the ground. Mr. Justice Saini said at 155, paragraph 155, the pleaded case seems to apply the single meaning rule to the misuse of private information claim. The single meaning rule is an artificial device developed to apply for claims in libel and slander on constant grounds specific to that area of law. The rule has no place in an MPI claim. In my judgment, it's an error for the claimants to seek to define the allegedly private information by reference to the single meaning rule.
Well, this, I think, reflects something that was said by the Supreme Court in ZXC. I think that's where Mr. Justice Saini got this, because at paragraph 112 of ZXC, they said, we consider it's inappropriate to read across the concept of a hypothetical reader from the tort of defamation into the tort of misuse of private information. So, although he doesn't actually spell that out, I think that's where he got it from.
They will be, in which case there's even higher authority.
Well, it's higher authority.
About the rule.
This was about whether to apply the principle that the ordinary reasonable reader is not unduly suspicious or avid for scandal, and therefore would not conclude from a report that someone was under arrest that they were guilty. All well-known stuff in defamation, and the Supreme Court rejected that submission. So I think it may go beyond Mr. Justice saying.
Yes, I'm grateful for the reference, my lord. Of course, these cases aren't specifically on the Charleston point, but your lordship did recognise when granting the permission.
No, they aren't. No.
Charleston is a sub-rule of the single meaning rule. So just to recap what I've got to, and I'm making good progress. Charleston is not the product of a deep analysis of how competing rights ought to be balanced in a publication case. It was simply a case that spelt out the necessary implication of two principles of libel law that weren't challenged in that case, and which no one tried to defend as reflecting some sort of fundamental fairness. So we don't follow why Mr. Justice Swift described Charleston the way he did, but it goes beyond that. Not only is it not all that the judge thought it to be, it's also inapt, we say, to transpose a Charleston approach into a fair processing case, given what we've already considered about the law of fair processing. And that brings me back to what I was saying about the fundamental difference in perspective the court has to take when assessing a fairness complaint and when assessing an accuracy complaint. Libel law is entirely concerned with the effect of a publication on third parties. You only get a remedy where the publication has had a seriously negative effect on the attitudes of third parties. It gives you no redress where a publication has merely caused a claimant distress or where it's caused pecuniary loss without also causing reputational harm in the minds of third parties. And the court in a libel case is faced with a binary threshold question. Is the statement complained of defamatory at common law or not? And the common law's developed rules for determining that question, including the single meaning rule, the rule in Charleston, and what's often called the consensus requirement, the standard being the standard for right-thinking member of society. But fair processing is not, or not essentially, concerned with impact on third parties. It's essentially concerned about the impact on the data subject and whether what has happened departs unjustifiably from what he reasonably expected to be done with his data. If it does, then the data subject gets to be compensated for distress and pecuniary loss, regardless of how the publication has affected third parties. Now, there is a claim for reputational harm in this case, but that shouldn't obscure the fact that this case is not fundamentally about the effect on third parties. So the binary question that arises in libel about whether publication would have this or that effect on readers just doesn't arise in a case based on fair processing. Because in our case, the unfairness lies in the mixing up of personal data of one person with another. We say that's straightforwardly unfair, just as would be unfair for a credit reference agency to score my creditworthiness by reference to someone else's financial history and not my own. It's just not what I would reasonably expect to happen. But whether readers would have been misled does arise, we say, as a question in our case, but it's not the fundamental binary threshold question that arises in defamation or in a complaint of inaccuracy. It arises at stage 3, the balancing stage. There's no logic, we say, saying that it should be approached in the same way as it's approached in those other causes of action, because precisely it's a balancing exercise, and the fact that some but not all members of the reading public may have been less misled may be enough to swing the balance one way or the other. And we suggest that adopting a Charleston-style approach that brings real question marks about whether the law can comply with the principle of effectiveness, which was part of the law at the time that this decision, this piece of processing took place. Because if the judge is right, then however much the defendant's processing departs from the claimant's reasonable expectations, however much distress is caused, however much pecuniary loss is caused, the claimant can't get a remedy unless he can show that the article as a whole is misleading. Coming back to the judge's proposition, the Charleston rule embodies some principal balancing of competing public interests. Not only is it wrong, as I've endeavoured to show, but that necessarily entails a proposition that in taking the approach for which we advocate, that would fail to achieve the correct balance between the data subject's interests and the rights of the media and the public. That's the defendant's position, and it's convenient just to explain now why we say it's wrong. Under our approach, the defendant gets 3 chances to resist a finding that the processing is unfair. First of all, they can argue that the processing that they've engaged in doesn't in fact fall outside what a reasonable person in the data subject's position would expect. That gives the press a wide latitude, particularly for people who, like Mr. Vince, choose to put themselves in the public eye or do newsworthy things. That they can't assert a reasonable expectation that they won't be written about in the press, or that they'll only be written about in some flattering, uncritical way. Second, if the processing does confound the reasonable expectations, the press can nevertheless argue that it had a countervailing interest in processing in the way it did, that's sufficient to outweigh the harm or risk of harm processing is entailed. And in an ordinary case, that may not require very much at all. It will often suffice for the defendant simply to say, well, we had an interest in telling the story the way we wanted to. Complaints about particular choice of words or the general tone of an article will probably fall away at that point. It's only where the particular processing complained of is both really unexpected and carries a significant risk of harm that a case may fail for a defendant at that second, third justification stages. Probably only going to arise in headline and captions cases. As the editor's code that we were discussing earlier now recognises, headlines do have a special status. There's a specific requirement in the code that headlines should be supported by the text. It's under the rubric of accuracy, but it's essentially a point about fairness and a recognition of the particularly particular capacity for unfairness arising from headlines and photos. And then thirdly, even if the processing is objectively unfair, there's still the journalism exemption. So we urge you not to be beguiled by arguments about negative consequences for the press as a whole, or that our position strikes the wrong balance. An unfairness complaint against a newspaper is still going to be quite a rare thing, and this is a rare case. What the defendant does in their skeleton at paragraphs 49 to 50 is to argue that our approach to fair processing is not reconcilable with Article 10 because of the breadth Article 10 gives to matters of editorial discretion. As to that, can I just remind the Court of what Lord Justice Warby said on that topic in Sitcree? That was a privacy claim where the court had to conduct an objective balancing exercise between the defendant's reasonable expectation of privacy and the defendant's countervailing Article 10 rights. So very similar to the balance that I say arises in a fairness case. And it's clear from Sitcree that the journalists can't arrogate that ultimate balancing exercise themselves. But what is said at 113 in Sitcree is that the broad proposition that can be drawn from the authorities is that in assessing whether in the particular circumstance of the case the imperatives of free speech are such that privacy rights, which the court has identified, must be overridden, the court should show an appropriate degree of deference to professional expertise and judgment of the publisher. So some deference to the views of the defendant, but ultimately an objective balancing exercise in the court. Very briefly, can I just turn to our third criticism of the judge's decision in paragraph 38 of his judgment, and that's the point he makes about coherence in the law. I deal with this at paragraphs 40 to 41 and 56 in our skeleton. And I acknowledge there that coherence is a desirable thing when it can be properly achieved, but there will be circumstances that when it can't be achieved. And one area where it may well be difficult is directly effective EU legislation, because there you have the autonomous concepts that have to be respected, you have the principle of effectiveness, and unlike domestic statutes, there's no presumption that the legislators are legislating against the background of the common law or other domestic statutes. And of course, we've seen divergence in this field already in the case of Lloyd and Google in the Supreme Court. That was where the claimants were arguing that loss of control over one's personal data that was a form of damage for the purposes of data protection law, just as it has been recognised to be in the law of misuse of private information, and that should be recognised in data protection law on the grounds of achieving coherence. That was rejected by Lord Leggett for two reasons. First of all, there was no, I'm not going to take you through it because I'm nigh on the time, but paragraph 113 in his judgment, Lord Leggett says two reasons for rejecting the argument of coherence. First of all, there was no available canon of construction that either mandated or permitted that interpretation of the word damage in the data protection law. Secondly, that the analogy was flawed in any event. And he said it wasn't enough that the two regimes aimed at a general level to provide protection for the same fundamental value. And he pointed out various distinctions between the two regimes of data protection and misuse of private information. And we say that our case is stronger than Lloyd in this respect, because there's nothing in EU law or guidance on the fairness principle that suggests that the Charleston approach is right. Common law, defamation and data protection don't have a common source any more than data protection law and privacy. And the fact that the common law tort of misuse of private information happens to protect Article 8, which is also protected by data protection law, wasn't enough in Lloyd. And we say there's no proper analogy between defamation law rules on meaning and data protection principles on fairness. Because, as I've explained, defamation law is fundamentally concerned with the impact of words on third parties and starts with a binary question of whether words that would or would not lower the claimant in the estimation of third parties, whereas fairness is fundamentally concerned with the effects of processing on the subject. And indeed, as I pointed out in the skeleton, fairness is scarcely recognised in defamation law as a value at all.
Would it possibly follow from that analysis that the harm that can be compensated in a fairness complaint doesn't overlap in the way that you claim in the particular claim with the harm that can be compensated in an inaccuracy complaint? You're not arguing that the first instance authorities from me about inaccuracy are wrong. So let's work on that assumption that they're not. And that it may be that inaccuracy complaints can lead to an award of compensatory damages for reputational harm, as happened in Arden by concession.
Yes.
If what matters in fairness is the impact on the data subject, it may just be the feelings that get compensated, because any reputational consequences are not a result of the unfairness, because the unfairness is about the relationship between the data controller and the data subject.
That's a possibility that we expressly recognise in the skeleton. And yes, there is debate to be had about when reputational damages should be awarded. Should they only be awarded where it's open to the defendant to say what I've published is true, therefore, or when the claimant has to say this is false. And that's not the gist of our complaint here. I'm not making a concession about that yet, because there's quite a lot
I
to think
understand.
about.
I'm just trying to turn over my mind to
But
the point, because quite a lot's been said about the scope of reputational damages, some of it affirmative, some a bit tentative, and some of it a bit ambiguous. I'm thinking of ZXC. It's not very clear what the Supreme Court was indicating it might think
yes, and then
about reputational damages in privacy, which is another separate topic.
and it all has to be brought within the autonomous concept of non-material harm.
Yes.
As well, so that's why I'm not conceding it, but it is certainly a possible consequence of my analysis that could be the outcome of the damages stage. But that doesn't affect prospects of establishing liability in this case.
Well, that was the other related question I was going to raise with you. It's a tort, we're told, for some purposes anyway. Is it a tort that's actionable without proof of harm? Is contravention, although not something that gives rise of itself to a right to compensation,
we accept
that gives you
justice.
a right to judgment on liability, or do you have to prove some harm before you get that?
We would have to prove relevant harm, just as the court said so in Lloyd and Google. But it's clear we established some harm here, because he spent £900 of his own money on press reading to get the article taken down. So we got pecuniary loss at the very least.
Yeah.
That's not disputed. Can I just turn my back a moment? I appreciate I've been going slightly fast in those last stages, but it is important, I think, we should hear from Mr. Callas on the visa process point, unless you have any questions for me at this stage on the ground to fairness point.
No, thank you. Mr. Callas.
My lords, my lady, I'll be addressing ground one of the appeal, which is that Mr. Justice Swift erred in striking this claim out as an abusive process. Slightly unusual wrinkle being that he decided very clearly, in accordance with our submissions, that it wasn't an abusive process in the sense of Henderson abuse, even though that was the only basis on which the application had been made. Our ground of appeal, just for your Lordships and your Ladyship's reference, can be found in the core bundle, tab 2, page 14. There is a respondent's notice in this case, which again, for the court's note, is at core bundle, tab 3, page 17. I will, if I may, largely deal with some of the objections in the respondent's notice in reply, save to commend to the bench our skeleton argument at paragraph 17 to 24, which makes some general objections to the respondent's notice. We say that this court is as bound as Mr. Justice Swift was by this court's decision in Warby, and there's no attempt to say that it wasn't. And so I think it comes down to a proper construction of what Warby actually decided in its application of the facts of the case, but I'll let my learned friend Mr. White develop that. My submissions are going to take 3 parts, and I hope to be certainly no longer than half an hour. The first part is to review just 2 authorities for legal principles. That's going to be Mu and Adine and this court's decision in Orgy and Nagra. Secondly, I'm going to look at the application that was actually made by the defendant below and the evidence that was before the judge on this part of the application, because most of the evidence was geared towards the summary judgment crossing applications. And thirdly, I'm going to consider the relevant part of Mr. Justice Swift's judgment under appeal, which is to say, according to the judge's refusal of permission, paragraphs 24 to 29 of his judgment. Those will be the 3 parts. Turning first then in the authorities bundle to Mu and Adine. This can be found at tab 14 of the authorities bundle, page 416 is where the headnote begins for those working electronically. I'm so sorry. Tab 12. It's convenient just to begin with the headnote. Put very, very briefly, the claimant's claim concerned Home Office publication concerning the claimant's conviction before an international criminal tribunal in Bangladesh that he said was grossly unfair. His claim was struck out, and the strikeout upheld by a majority of the Court of Appeal, David Victoria Sharp, President of the King's Bench Division, and Lord Justice Dingemans, on some admixture of Hunter abuse and Jamil abuse. The law of libel has probably done more than other parts of the law for coming up with different forms of abusive process that get names. We had sort of Golding and Sperrin abuse, Jamil abuse. We weren't responsible for Hunter. We're not responsible for O'Reilly and Macklin abuse, but we've definitely pulled our weight, including ones specifically on delay, like Grogan and Doctor. Hunter abuse, broadly speaking, we say, following this decision of the Supreme Court, has at least 3 elements to it. There has to be a conviction that's being challenged, that the claim is a collateral attack on a prior conviction. The court that convicted the claimant has to be a court of competent jurisdiction. And we know, in response, because of the first holding of the Supreme Court, which can be seen in the headnote at the bottom of page 416 and top of 417, that it will only be the case if the claimant had had a full and fair opportunity to contest the facts that led to that conviction. In the present case, he had not done so. He was tried in absentia. The death penalty was on the table. There was an issue with lawyers actually taking his instructions, and accordingly, that was why Hunter abuse could not apply, because that third element fell away. There's an interesting analysis in this judgment as well, in the second ground of appeal, as to the nature of Jamil abuse. The decision in Jamil concerned publication to 5 people in the jurisdiction. It was essentially a case on jurisdiction about there being no real and substantial tort having been committed here. And it's often known by the earworm of the game not being worth the candle. In this case, it was pointed out that it's not really correct to just describe Jamil as being case about whether or not the cost of the proceedings would be disproportionate to the small value claimed. It's whether there's something that is only minimal or trivial being claimed, and as a second step, such that the proceedings would themselves be an interference in Article 10 rights. That had traditionally thought to be the defendant's Article 10 rights. There is an interference by having to fight £1 million libel actions over £10 worth of damage. The Supreme Court was prepared to at least consider that maybe it went further. But the real crux of Mu'minadeen, and the reason that it's particularly important in this case, is the third approach, whereby the majority of the Court of Appeal had considered that there was at least large part of hunter abuse was made out, even if the claimant hadn't had a fair opportunity to put his case to the tribunal of Bangladesh. And there were certainly also facets they considered of Jamil abuse, and that therefore the claim should be struck out as an abusive process, essentially borrowing some admixture of the elements of Hunter and Jamil put together. The Supreme Court was not impressed by this particular approach and preferred very strongly the dissent of Lord Justice Phillips, who had described this approach as unprincipled. And the relevant section is paragraphs 121 to 123. That's on pages 464 to 465 for those electronically. On the facts of the particular case, it's possible that more than one form of abusive process may be relevant. It's also possible that some of the categories of abusive process may overlap. The approach adopted by the majority of the Court of Appeal proceeded, however, on a different basis. In relation to Hunter abuse, they concluded that even if the claimant's challenged his conviction did not constitute abuse, it could nevertheless contribute, along with other considerations, to the conclusion that the claim was an abusive process. In relation to Jamil abuse, although their reasoning is less clear, they appear to have treated their finding that the value of the claim was greatly exceeded by the cost of the litigation as a factor which contributed to an overall conclusion that the claim was an abusive process. The supposed unfairness resulting from the Secretary of State's difficulty in establishing a defence of truth appears to have been treated as another factor in the overall assessment. This approach was rightly described by Lord Justice Phillips at par 84 as unprincipled. The Hunter principle and the Jamil principle protect different aspects of the public interest and have different rationales. When neither principle is satisfied, the considerations which are relevant to each principle cannot simply be lumped together. If they are considered to be relevant to some other principle, that principle has to be identified and defined. So this is essentially criticising the majority of the Court of Appeal for a sort of a mix and match approach to abusive process, whereby sort of half the elements of Jamil and maybe half the elements of Hunter are smushed together in an admixture to produce abusive process. And the Supreme Court says that simply will not do. That's not to say, and it's very clear, that the categories of abusive process, insofar as they are well defined, even if they're not fixed, they clearly can overlap. They're not mutually exclusive. But the factors that go into each category of abusive process have to be considered in the context of that particular form of abuse. It's not enough to say, well, this factor was there when we were considering Hunter abuse, and even though Hunter abuse wasn't made out, I'm just going to roll it over into my assessment on the next basis. And we will see in Orgy an example of how this is done, we say, entirely correctly. The governing authority, we say, that applies to this case, and Mr. Justice Whipple was correct in this sense, is this Court's decision in Orgy and Nagra, which is at tab 11 of the bundle, starting at page 396. The facts are a little messy, but I would encourage the Court to read this authority in its entirety. But broadly speaking, there had been a trespass claim. The only decisions that had survived in the trespass claim were amendments that were allowed to it, but the claimant didn't include in his final set of amendments the malicious falsehood claim that he had also brought. It was the malicious falsehood claim, which did arise out of the same facts, that was essentially struck out.
Malicious prosecution.
I'm so sorry, malicious prosecution, not malicious falsehood. Thank you. There appears to be possibly some difference of opinion as to what Orgy actually decides. I would like, if I may, to begin on page 405 of the authorities bundle at paragraph 41. Paragraphs 41 and 42 define the two issues in the leading judgment of Lord Justice Coulson, with whom Lord Justices Stewart, Stiff and Mugie agree. first issue at 41 is whether the rule in Henderson and Henderson is generally applicable to a case like this, where there has been no prior determination of any substantive issue by the court. The word prior there, I attach quite a degree of significance to, because the question is prior to what? And we say it has to be prior to the bringing of the claim or the raising of the defence. That's the formulation that's used by Lord Bingham in Johnson and Gore-Wood. Bringing and raising are used throughout the authorities. That there is indeed, you will see tab 9 of this authorities bundle, a recent authority of this court in Warburton, precisely on what bringing or raising meant, and it meant formally bringing before the court by way of a formal pleading, issuing a claim, issuing an application. It doesn't mean just raising in correspondence, that's not enough. So we say that on a proper understanding, the issue that was being decided in Orgy by Lord Justice Coulson is whether or not there has been a relevant determination, a substantive determination, prior to the bringing of the claim that is said to be Henderson abuse. That was the first issue. The second issue is explained in paragraph 42. So sorry, I've just lost my place. And paragraph 42, and in some ways this is more important for our ground of appeal because the first issue really goes to my learned friend's respondent's notice. Secondly, there is a separate question which, so it seems to me, arises if both judges below are wrong and the rule in Henderson does not apply to this case. That turns on whether what was said to District Judge Stewart and its consequences amounted to an abusive process, such that regardless of Henderson, there were sufficient grounds to strike out the malicious prosecution claim under CPR Rule 3.42b, and that's considered later on. So paragraphs 44 to 54 are Lord Justice Coulson's decision on the first of these issues, a review of Henderson. The quote will be very familiar at 45, an even more familiar quote from Lord Bingham in Johnson and Gore-Wood. You'll see at the top of page 406 of the bundle, third line of that quote, the bringing of a claim or the raising of a defence in later proceedings. There's no dispute between the parties, the point made by Lord Justice Coulson at 46, that Henderson, Johnson and Gore-Wood, although they were concerned with subsequent proceedings, equally you can have Henderson abuse within the same proceedings from an interlocutory decision. And so parenthetically, it might have been relevant had no application, had in this case an application to amend been made after the strikeout decision was handed down. It might be that Henderson would have applied to that amendment application within the same set of proceedings. The reason, again, it would depend on whether or not the way in which the claim was brought, whether by amendment or by new claim, was prior to or not a substantive decision on merits, which here is the decision on strikeout. So there's no dispute as to that principle, which Lord Justice Coulson attributes to his own judgment in Seal Austria, Tokyo. But what he says at 47, including by reference to an earlier judgment of Lord Justice Nugent, who was on the court, is that it's crucial to remember that whenever the rule in Henderson arises, the rule in Henderson requires a previous determination by the court. As Lord Hobhouse put it in Re Norris at 26, it'll be a rare case where the litigation of an issue which has not previously been decided between the same parties or their privies will amount to an abusive process. And it's on that basis that the case is fundamentally decided. It couldn't be Henderson abuse because in this claim there was no relative determination. In the present case, of course, there was no determination whatsoever. The first judicial decision that was made in this case, that was made in the libel claim, was to strike it out, and that decision wasn't handed down until a month after the data protection claim had been issued. And so, similarly to paragraph 49, the appellants could not be accused of trying to go behind some earlier determination of the court because there had not been one. The only determination you see at the bottom of paragraph 50 was permission to make some re-amendments. At paragraph 55, Lord Justice Coulson then considers, well, if this isn't Henderson abuse, could it nonetheless be another form of abuse of process. There are several. There can be abuse of process because of a particular litigation misconduct, lying to the court. There could be abuse of process because the claimant is pursuing proceedings for an entirely collateral purpose, not because he's actually interested in the remedies that the court alone can grant in his claim. In certain circumstances, although they're very limited circumstances, may be confined to the law of defamation, delay alone or want of prosecution can give rise to an abuse of process. And Lord Justice Coulson considers these. He looks at the law generally between paragraphs 55 to 59. He points out at 56 that Lord Bingham has said it needs to be shown that the conduct of the party in question is so objectionable that they should forfeit their right to take part in a trial, such as where that party is determined to pursue proceedings with the object of preventing a fair trial through the use of forgeries and perjured evidence. At 57, he cites Aldi Stores, which is a case that both sides are familiar with at first instance, which puts the onus on both parties to make sure that the court has the full picture for case management. If somebody raises a second claim, they shouldn't be keeping it secret and keeping it away from the court or the other party. And similarly, a party who thinks that a second or further claim is an abuse in Henderson should say so quickly rather than just waiting to strike it out. At paragraph 58, Lord Justice Coulson points out that striking out a claim is a draconian remedy. So, in my submission, whatever the species of abusive process that's alleged, once there has been abuse found, which is a question of law, it's an evaluative question of law, there is then a further question as to what the remedy for that abusive process should be. If it is something relatively small that can be dealt with by way of a cost sanction or some other measure short of striking out, then that path can be taken. It's not the case that every case that involves abusive process necessarily needs to strike out. And that's the gravamen of 58. The three types of abuse in this case were said to be dishonesty and deception at paragraph 61 to 69. The flurry of different amendments and the fact that even the fifth version didn't include the malicious prosecution claim was said to be oppression at paragraph 70 to 72. And the inordinate delay which had plagued the underlying proceedings and had been laid at the door of the appellants by both the judges below, Lord Justice Coulson took a slight difference of opinion as to where responsibility for that lay, but ultimately found that even though there had been very significant delay, that alone was not enough either to make it an abusive process outside of Henderson. Very quickly, Lord Justice Stuart Smith at 79 agreed with both judgments, and Lord Justice Nugee at paragraph 84 repeated the fact that Henderson belongs in part to the law of res judicata, and that's citing our skeleton argument. It's Lord Sumption in Virgin Atlantic at paragraphs 23 to 25. And that's why it's necessary for there to be a prior decision before the claim is brought, whether by new claim or amendment. That's all I want to say on the law. The facts, I think, can be taken relatively quickly, and unfortunately, given the bundle referencing issue, almost entirely from the supplemental bundle. What I'm not going to repeat is our skeleton argument gives, at paragraph 5, gives a very basic chronology. Paragraph 4, which is core bundle at 25 to 27, gives a very basic chronology. I don't understand any of that to be disputed, but I'll be corrected. This is not a case where I actually think there's been any dispute of primary fact at all. So it's not a case that turns, in that sense, on contested evidence. In the supplemental bundle, the defendant's actual application is at tab 4, pages 9 to 14. It was both the strikeout on the grounds of Henderson and also reverse summary judgment. The witness statement in support is at tab 6 by Lindsay Warwick. At paragraphs 5 to 17, that's pages 24 to 25, there is a relatively uncontentious account of the procedural background of the proceedings. And then over the page at paragraph 18, this is the particular ground, all that's said is the second claim is vexatious and an abusive process in the sense identified in Henderson and Henderson. Because the claim for unfair data processing should, if it was to be raised at all, have been raised in the first claim. The defendant therefore asked the court for an order striking out the claim pursuant to CPR 3.24b. There was no other basis of application. No other basis was argued at the hearing. Muinadeen wasn't even cited. That was the basis upon which argument proceeded, and it was based on whether or not the decision of Orgy and Nagra necessarily meant that the Henderson application should fail, and in that sense, Mr. Justice Swift agreed with us. There's also only one paragraph of the responsive evidence that is relevant. At tab 8, it's the witness statement of Mr. Double, with Brett Wilson, who acts for the claimant. And although a long paragraph, paragraphs 113 to 115, this is really the only paragraph that's relevant to the Henderson application. He points out that it's primarily a matter for submissions on law, but the sub-paragraphs in summary, paragraph 45A is pointing out that there's no issue estoppel. Obviously it's related, but there's not an issue estoppel being in question here. B is rather important just because for the way in which it appears to have been relied upon by the judge. Mr. Double says, in any event, the claim and data protection claim was issued and the defendant provided with a copy of the claim form before His Honour Judge Lewis had made any determination at all. You can see that's obviously relevant to the Orgy criteria. He continues, the claim could have been introduced by way of an amendment in the original proceedings, but given that the parties were awaiting judgment of the defendant's strikeout application, and this would have required permission consent, it was considered more convenient to issue a new claim, which avoided potentially burdening the court with a further application while the parties were awaiting hand-down of the judgment. Issuing the claim form was a way to get the data protection claim on foot immediately and unilaterally, before there had been any decision. Obviously, issuing afterwards or applying to amend afterwards might have engaged the Henderson position. The claimant has been entirely candid, he continues at subparagraph C, with the defendant about his data protection claim. He first notified the defendant in the letter of claim dated the 26th of June 2023 about the breach of his data protection rights. Further, the claim form was sent to the defendant's solicitors on the 6th of June 2024, some 6 months before the defendant made its application to strike out reverse summary judgment. I just note parenthetically from the date, the publication in question took place on the 8th and 9th of June 2023. The second claim, the data protection claim, was issued within a year of that publication. Normally, although there's some conflicting dicta about whether it's limitation as a tort or limitation for breach of statutory duty under the Limitation Act, it's, I think, generally accepted that the limitation period for data protection claims is 6 years. This one was brought not only within that period, it was brought within the 1 year that would have been possible to bring a libel claim, and that is relevant to purported delay and prejudice that's alleged. Mr. Double continues, the defendant did not seek to challenge the claim immediately. They sent an email on the 21st of June 2024 saying they agreed that it was neither necessary nor proportionate to engage in a dialogue over the proposed new claim, reserving their client's rights. He then cites Aldi stores. At E, its first mention of Henderson abuse was in the post-hearing submissions, and we will come on to see those. And then finally, at the end of subparagraph G, he concludes, plainly the defendant has suffered no prejudice as a result of the second claim. It's not filed a defence in either claim or had to undertake any work that would be duplicated in the data protection claim. Matters are at an early stage, and the data protection claim is well within limitation. Just so the court has the references, and this should only take me just a couple of moments. The notification of the second claim, the letter is on page 192 of the bundle. And the email saying, as you suggest, it would be neither necessary or proportionate to engage in a dialogue over the proposed new claim at this stage, other than to say that our client's rights in regard to the new claim are fully reserved, is on page 193. You'll see over the page that then the draft judgment was promulgated. And then at page 195, while the parties are seeking to agree in order, it's the defendant that proposes an additional provision to the draft order of the judge striking out the libel claim. And the provision that was sought agreement to, and then submissions were made in support of, because it wasn't agreed, was that the second claim, the data protection claim, should be stayed pending payment of the costs of the first claim that were to be ordered. There is a dispute. You can see the effect of that in the draft order on pages 196 to 197. The disagreement between the parties on page 198 and 199. On page 200, you will see that the claimant agreed to pay the costs in the sum of £35,000. So that was an agreed cost of the first claim. At page 206, the date on 207, you'll see it's the first mention of Henderson abuse. It's on the 12th of July. In the submissions in support of the stay. The response from claimant's then counsel.
I think we're getting into the weeds of this, Mr. Callas, a little bit much.
A little.
The substance is clear, isn't it, as to what happened?
Yes, my lord. 216 to 218 then is the refusal of that stay. And then this service by agreement on pages 223 to 224. There's nothing in the witness statement whatsoever of Mr. Gregory on abuse of process. And so the only evidence that goes beyond the mere saying this is Henderson abuse in the first witness statement of Ms. Watkins is in her second witness statement at paragraphs 7 to 19. That can be found at supplementary bundle 12. Now the point made in particularly at paragraphs 14 to 19 is that there was indeed prejudice being caused to the defendant. Three bases are given for that. I wish to show that there's no merit to those, because we're looking here at non-Henderson abuse, if the judge was correct that Henderson didn't apply. The first is that the first claim, the libel claim, had cost the defendant almost £49,000, but the agreed costs to be paid, and which had actually been paid, was only £35,000, and therefore the defendant was out of pocket on the first claim. There are 2 points to make about that alleged prejudice. The first is it was the agreed costs, and the second point is there's no possible causation. Even if the second claim never gets made, that shortfall exists. It doesn't result about whether or not the data protection claim was brought on the original claim form or by way of a second claim. That couldn't possibly affect the costs of the libel claim. At paragraph 15, it makes a general point with which we don't demur that in litigation some costs are always irrecoverable. And so a second claim means that there's a possibility of unrecoverable costs. But again, that's about the principle of whether the claimant should be allowed to make a claim at all. It doesn't really affect whether or not, it doesn't rest upon, the difference between whether it had been brought at the time or whether it was brought by the way of the second claim form. The third one at least begins to look at the distinction between had the claim been brought in the first claim form and it not being brought until the second. It claims at first in paragraph 16 that there's some sort of loss of efficiency in the final sentence. The difficulty with that is that if you look on the previous page at paragraph 11, in response to the claimant's point that they could have called for service at any point after the 6th of June, is what it says, whilst I accept that the defendant could have requested the claimant serve the claim form upon them sooner, this would have had the effect of having two claims running simultaneously on substantially the same issues at different stages, leading to unnecessary procedural complications, particularly if the defendant's application to strike out the first claim was unsuccessful. So this is a bit of cakeism here. Apparently the defendant both did and didn't want to have both the proceedings on foot at the same time. 18 to 19 raise the only real issue between whether it makes any difference that this data protection claim was raised in October of 2023, or when it was in fact raised in June of 24.
I think you can take this pretty shortly, Mr. Callas. I think we've read the documents.
I'm grateful, my lord. The point being...
See what Mr. White says, and if he makes any progress, you can come back on this.
I'm grateful, my lord. Unless I can say further.
Thank you very much. Thank you. Mr. White.
Well, I'm going to deal with the points in the order they appear in the notes of appeal, so I'll respond to Mr. Callas first on ground one. We made two submissions on ground one. We firstly submit that on the findings made by the judge, he should have upheld the defendant's submission that the second claim was a Henderson and Henderson abuse. And he shouldn't have accepted the claimant's submission that the Henderson principle has an exception where the second claim was issued before the first was determined.
And was he not bound by Lord Justice Coulson and Lord Justice
He certainly was, if that's what Orgy decides.
Right.
But in my submission, it decides nothing of the sort. There was, and I'll just trail this, there was no determination at all in Orgy, and the temporal focus one sees, I think it's in paragraph 49 of Lord Justice Coulson's judgment in Orgy, is on the point in the proceedings at which the argument about Henderson and Henderson abuse takes place, whether at that point in time there has been a prior determination. At that point in time in Orgy, because there was never any relevant determination, there had been none.
But there has here, you say.
There has here. We have the strikeout of the first claim. What has happened before that strikeout is the claimant, having seen how the wind was blowing in the strikeout application, issued a second claim and deliberately held it in reserve pending the outcome.
They told you they were holding it in reserve.
They told us that, but that doesn't alter the fact that that was a strategic choice they made. That meant that by the time they pursued the claim, served it on us, and brought it forward, there had been a determination.
So you rely on the second sentence of 49, there'd been no determination by the court of any substantive issue at the time of the hearing before Judge Payne.
Precisely. And if there were, I'm getting ahead of myself slightly, but if there were an exception from the rule in Henderson and Henderson which exempted from the consideration by the court of abusive features of a second claim, in any case where the second claim happened to have been issued before the first was determined, then it would be a free pass for a claimant to issue, for example, a number of claims and bring them forward sequentially when one failed. That can't be the law. It would avoid the scrutiny, the taking into account of all relevant facts that Lord Bingham refers to in Johnson and Gore Wood, simply on the strategic advantage supposedly gained by issuing the second claim but not bringing it forward and waiting to see what happened in the first. I mean, Lord, there's no, apart from Orgy, what's notable in the appellant's argument is there's no other authority that suggests there's any such exception from the Henderson principle. I've read all the way through Spencer Bauer without finding any suggestion that there's a technical exception of that sort.
I thought they relied on two authorities, one of Lord Justice Nugent himself, Wilson and McNamara, and one Koza, Lord Justice Popplewell, or maybe Norris. But are they not ones 47 in Orgy? I thought that. It's crucial to remember that whenever it arises, the rule in Henderson requires a previous determination by the court.
Yes,
As Lord Hothouse said.
those don't impact on my suspicions. Indeed, we rely on Seal and Koza for the proposition that there is an applicability of the rule in Henderson and Henderson at later stages of the same litigation.
It's pretty hard, isn't it, to invoke Henderson and Henderson in a case less than a year from the alleged problem, and they've changed their lawyers and they decide to put another claim in reserve, tell you about it, you don't complain until much later. Why is that not just a normal rough and tumble of litigation?
Well, my lord, the judge made a number of findings which aren't questioned by the appellant about what he made the required findings about all of the relevant factors, whether there was any difficulty in bringing the two claims at the same time, whether there was a proper explanation, for example, of the decision, having raised it in the letter before action, to leave it out of the first claim.
Well, it was legal advice, probably, wasn't it? I mean, we can be that's what happens. They thought they obviously wanted to challenge Charleston. I don't know what they wanted to do, but they made them change their minds. I mean, but the point is, this is about vexing you with things that have already been decided and should have been brought forward. I mean, your best case is, well, of course, they should have brought both claims at the beginning, but they did so quickly later that sort of Henderson does seem quite a blunt instrument for this. I mean, you're not saying we have to strike it out. You have to strike it out. There will always be at court's discretion to say this was not so bad that it needed to be struck out, wouldn't there? Even under Henderson.
Well, my submission, and I want to show you the judge's findings, is the judge's findings which aren't challenged would have led to the application of the rule in Henderson had he not thought it was excluded by orgy. He wrongly thought it didn't bite because of orgy.
But if it does bite, sorry, what I'm asking you is if it does bite and you're right, let's assume for this purpose you're right, as to the law, are we forced to strike out a claim when Henderson bites?
My lord, it's, as Lord Bingham describes it in Johnson and Gorwood,
Exactly.
it's an intense focus on the relevant public policies and
Unfairness.
all of the facts of the case.
It's an unfairness thing again,
But my lord,
with a completely different meaning to the term unfairness, I'm sure. Come to that, perhaps.
But my lord, there is a basic principle that we rely on, that a party is expected to bring forward all their points within one set of proceedings, and to have a second bite of the cherry, having brought one case, fought it through, the defendant's been vexed by that one, then say, I've got another way of putting the case. I could have put it in the first one, but I didn't. The judge describes it as attritional, and it is attritional to bring a second case that you could and should have brought within the first claim.
Yeah. Okay, well, I certainly get the point.
Yes. But my lord, it's important for the development of the law for this court to consider whether the claimant is right, that there's an exception to the Henderson principle, where the second claim was commenced in the sense of technically issued before the determination of the first claim, because that would make a hole in the court's ability to control abusive proceedings, taking into account the Henderson factors. And it's not one for which there's any prior authority, and not one which in our submission which arose for decision in orgy. If orgy isn't authority for that exception, then the court has to look at whether it's a desirable exception, or whether the court ought to be able to consider the abusive features of a second claim, whether it happens to have been issued a few days before the determination of the first, or afterwards.
Well, you say orgy anyway was actually cannot possibly be authority that there's such a rule, because in that case, the case, by the time it actually came, oh no, that's our case. I'm sorry, it's a bad point.
Yeah, what I say about orgy is it's a completely different case. In our case, we have a determination.
Yeah.
The first claim is struck out.
Yeah.
We then have an argument about whether Henderson abuse stops the second claim, which could and should have been part of the first, from being brought forward. And the judge identifies a whole series of factors which would normally result in a finding that it was Henderson abuse, but because of orgy, says it doesn't apply. And I'm going to make an alternative submission that the judge was entitled to strike out the claim even if he was right that orgy created that exception to Henderson abuse, on the basis that the bringing of successive claims based on the same subject matter is vexatious. And that doesn't depend, that's a separate category, Henderson abuse. But my primary submission, and it's the point raised by the respondent's notice, is that on the findings made by the judge, he should have struck out the second claims of Henderson abuse, and would have done so had it not been for his misreading of orgy.
Yeah.
Can I start with the findings of the judge? I know we've all read the judgment very carefully, but could I take you quickly, starting in paragraph 23?
Yeah.
This is where he considers the relevant factors on the assumption that Henderson is not available. We say that's an incorrect assumption in the opening sentence, but the findings he goes on to make are very important. He's satisfied that the UK GDPR claim should be struck out as an abusive process. There's no question that the UK GDPR claim could have been commenced as part of the claim issued on the 2nd of October 2023. All the matters now relied on in support of the claim were known to Mr. Vince and his advisors, and of course one can see that from the letter before action. It was using the familiar language of Henderson, he concludes in 23 that the claim could have been brought. He then goes on in 24 to consider whether it should have been. There was every reason why the UK GDPR and defamation claims should have been brought in the same proceedings. Both claims arose out of the same event, publication of the Mail, the article in the Mail Plus and Daily Mail. Both claims rely on the same factual circumstances, namely the juxtaposition of the headline, photographs and caption. And then this is important. What he calls the contention is this essence of the claim in both cases, and the contention that the combination of the headline and photograph created the misleading impression that Mr. Vince had been accused of sexual harassment. In one claim, this was said to be defamatory. In the other, the misleading impression created was said to comprise unfair processing of personal data. Well, those findings are important because they emphasize that the claims are essentially duplicative. Apart from the cause of action, the components of the two claims are in substance the same. He goes on...
They say no, not. I mean, that's been the whole substance of the submissions made to us this morning.
Well, my lord, the pleaded case, which the judge summarises in paragraph 38, which was said by Mr. Eardley to be a mischaracterisation of the claimant's case, does plead that the unfairness, just go if we may to paragraph 38 of the judgment, Mr. Vince's complaint is that the processing by way of publication was unfair because the headline and the pictures gave a misleading impression. He contends that because of the unfair processing, his reputation has been damaged. Well,
Yeah, that's been directly criticised.
But it comes straight from the
being
pleading.
as being wrong in law.
It comes straight from the pleading in tab 13 of the core bundle.
Mm-hmm.
Paragraph 15, the processing complained of, publishing to a very large readership with a suggestion, particularly to readers who read only part of the article, that the claimant was the labour donor who was accused of sexual harassment, was unfair because it was unexpected and unduly detrimental without justification for the adverse impact. It created a misleading impression in the minds of those receiving the personal data.
Unduly unexpected and unduly detrimental without justification. I mean, that sort of, and creates a misleading impression. But I mean, this is not to be construed as a deed. There's legal submissions have been made by Mr. Edley.
It's not construing it as a deed, it's looking at the substance. The judge is right, is he not, my respectful submission, to say that the pleading, it was unfair because it created a misleading impression. Is the substance of the case.
Yeah, I mean, you can't have a finding about you can't have a finding about things like this. It's a legal question. It's not a factual finding on which you can rely that we can't overcome if we disagree as to the law.
No, I don't suggest for a minute that that's the case. I suggest the judge rightly summarised the substance of the second claim, taking it from paragraph... And my lord, paragraph 16 goes on to say the claimant reasonably expected the defendant would not publish serious falsehoods.
Well, I mean, let's deal with that underground too, because I did put to Mr. Erdley, that there was a problem about the overlap between inaccuracy and unfairness, and I see that as a real point, but it's not. I don't think it's relevant to strike out.
Well, what I'm doing so far is identifying the factors which the judge had identified. And in my submission, paragraph 24 is unassailable. It is a correct description of the essential facts relied on and the contentions put forward. In the first case, using the cause of action defamation. In the second, using the cause of action data protection. And one of the mischiefs that Henderson abuse prevents is the bringing of duplicative litigation. And so if I'm right that the judge aptly characterises the commonality between the two cases, then we are in the territory of bringing a duplicative claim.
Well, at paragraph 39, the judge records the submission that's been made to us, that this is all about the reasonable expectations of the data subject. And I know he doesn't say use those terms again, and I know that there's tremendous criticism made on the other side of paragraph 38. But the fact is they're different. They are not the same, and he can say they're the same as much as he likes, but they're different causes of action with different juridical foundations, and for lawyers they're completely different, and they have all sorts of different qualities, and that's what, if we get that far, we're going to have to decide about.
Well, may I just couple on the suggestion he didn't come back to reasonable expectation? He does, paragraph 39.
That's what I said,
Yeah, it's the core of his ultimate conclusion, that the submission from Mr. Vince, to the contrary, focuses on his reasonable expectation not to be the subject of unfounded suggestions. So he does apply the perspective urged upon you by Mr. Eardley. He doesn't slavishly follow any rule of libel law or any applicable rule. He looks at relevant aspects. We'll come to this on round two. But he does...
well, I tell you what, Mr. White, how about we come to it all at 2 o'clock?
Yes, let's do that. I had noticed earlier that clock was a little slow.
Before we all get too hot and bothered and try and cool off. But we do have some air conditioning in here today, about which I'm quite pleased, because we don't always...
I'm very glad to be in here today. It's one of the most comfortable temperatures I've been in all day.
2 o'clock.
Well,